Judge Aileen Cannon has delayed the ruling of on whether or not a special master will be appointed to review the documents the FBI seized at former President Trump's Mar-a-Lago home. The Trump-appointed judge says she will issue a written ruling, quote, in due course. But she did make available a full list of the more than 11,000 items that were removed from the former president's home. So the saga continues, folks. For more on this, we are joined by our legal legend and the host of the podcast, The Dersh Show. He's also the author of The Price of Principle, Why Integrity is Worth the Consequences, Alan Dershowitz. Professor, always good to see you. Some people this week were making kind of a big deal that she didn't rule from the bench on this special master. She was never going to really do that. But she did release the list of items. Did we learn anything new here, though?
Yes. The issue is not what was in the list. It's what was not in the list. We have empty envelopes. And the only possible case that they could consider making against the former president and a future presidential candidate is not going to be mishandling of classified information. It would be the Nixon crime, obstruction of justice. And the only way you get an obstruction of justice conviction, and I don't think there's any evidence of it now, is to show that there was willful and deliberate destruction of subpoenaed material, which is what happened in the Nixon case. And so those empty envelopes could prove to be significant. If the government could prove that there was classified material in those envelopes, which are marked classified, and then that Trump himself or others under order from him deliberately ripped up or destroyed that material to prevent the Justice Department from coming upon it, that would be obstruction of justice. But that's total speculation at this point.
So, you know, we've been talking about the folks that may have worked at Mar-a-Lago, people kind of on the inside that fed the FBI information. That they would be who those people are, and their testimony, perhaps to a grand jury, would be really key to advancing this into some sort of a prosecution.
It could help and it could hurt.
Right.
I have to tell you that juries don't like bought witnesses. If these were people who were given deals, who may have been complicit themselves in moving documents or whatever, and the Justice Department said, hey, if you give us information, we won't investigate or prosecute you, those generally are not particularly good witnesses. They're good sources of information, but not good witnesses. But eventually, the names of every single person who gave information to the government will have to come out, and then the lawyers have to be prepared to cross-examine them and to challenge the veracity of what they've said.
Now let's go from Mar-a-Lago to Washington. Former White House counsel Pat Cipollone testified before a grand jury that has been impaneled in Washington over the January 6th riots. Talk to us about this grand jury and its potential targets and what you might expect to come out of this. Okay,
Pat Cipollone is a friend of mine. I worked with him, obviously, on the first Trump impeachment. He's very honorable and a decent man, and his statements will be taken seriously by the grand jury. But I don't see the case. President Trump's speech on January 6th was ill-advised. I would certainly have told him not to make it, even though he used the words peacefully and patriotically. He shouldn't have made that speech. But it doesn't even come close to being criminal. Under the Brandenburg principle, the leading Supreme Court case, that is advocacy, not incitement. So, you know, you get Larry Tribe, a zealot, who says on CNN that the president, former president, should be indicted for attempting to murder Pence. Shows you the extremes to which people will go to try to get Trump. But I don't think that there's any way he could be prosecuted successfully for January 6th. I think the only issue is obstruction of justice, and perhaps the Georgia case and the New York case. But I don't think the classified material or January 6th rise to the level of passing what I call the Nixon test or the Hillary Clinton test. The Nixon test, bipartisan support. They don't have that. The Clinton test is, what did he do that was so different from what she did?
Yeah, and I don't know what's going on with Larry Tribe. I mean, I think the guy's, kind of off his rocker at this point. But so just so that I understand, as we wrap up here, you don't think, even though the bar and the burden is very low, and you could, a decent, a bad lawyer from a bad law school can indict a ham sandwich, you still think that there's a good chance that they're not going to be able to actually indict him for either of these situations?
Well, I think they're able to do it. In the District of Columbia, you don't need a ham sandwich. You can indict a peanut butter and jelly sandwich in the District of Columbia. I don't think that wiser heads would seek an indictment unless they pass the Nixon test. Bipartisan support, something very serious, obstruction of justice. And it's just not there yet.
All right. The saga continues. Professor Alan Dershowitz, thank you for being here, sir.
Thank you.